Welcome to St. Louis on the Air and this month's Legal Roundtable. I'm Don Marsh. No shortage of legal issues to discuss this month, including a proposal to privatize Missouri's public defender system. A retired St. Louis judge has regrets for a 241-year sentence she handed down for a crime committed by a 16-year-old. And Washington University students look at gun violence and human rights. But the big story has to be the felony indictment for Missouri Governor Eric Greitens. Lots to talk about on that, and we will with attorneys Mark Smith, Associate Vice Chancellor and Dean for Career Services at Washington University. Bill Freivogel is Journalism Professor at SIU in Carbondale, and Rachel Sachs teaches at the Washington University School of Law. We'll talk about the governor's situation in just a moment or two, but first we have what I guess is popularly called breaking news anymore, and that is the Supreme Court. Bill Freivogel has ruled today on a DACA issue that is a setback, I think, for the Trump administration.
Well, it is. It's not really a ruling on the merits of that whole issue, but what had happened was that two federal judges, one in San Francisco and one in Brooklyn, had put on hold had said that President Trump had acted arbitrarily and capriciously when he reversed President Obama's DACA program, and so said that for the time being, until the case can work its way through the courts, for the time being, that the Trump administration had to continue to accept renewals by persons in the DACA program, didn't have to accept any new DACA registrants, didn't have to let DACA people back in the country if they had traveled voluntarily abroad, but had to accept the renewals. The Solicitor General on behalf of the Justice Department and President Trump had said, Supreme Court, this is so important. There's so many DACA people violating the law. I think they maybe cited 700,000 violating the law, that we need you, Supreme Court, to take this case right now and decide it right now instead of waiting for the federal appeals courts to hear the whole case. And the Supreme Court said it wasn't going to do that.
It wants a lower court ruling before it gets into it.
The Supreme Court only does this in really extraordinary cases, like way back when President Truman seized the steel plants, when President Nixon refused to obey the lower court decision on turning over the Watergate tapes. So this hardly is in that importance.
Rachel, you had indicated that the president's tweets were involved in the way the court moved today?
No, not the way the court moved today, but in the way the district court ruled on the question of DACA's rescission for the Dreamers, right? This is another case where the courts are citing the president's tweets in their rulings. The administration has said that these tweets are official statements, and in this case, those tweets suggested that the president supports the DACA program and that he attempted to end it for political reasons that are unrelated to those reasons advanced by his Justice Department. So they're being used as evidence of his motivation in ways that undermine his lawyers' attempts to argue their case.
I see. Okay. Anything to add to that, Mark?
I would just say,
move on?
I think we're putting off the inevitable, though. I think the Supreme Court is going to uphold Trump's ban down the line because he's now added Venezuela, so it's not all Muslim nations, and I think...
Well, that's different.
The DACA thing.
Right. You're talking about the travel ban.
And the DACA thing, we're just postponing it too.
Yeah, I think you're right in saying it's postponing thing. I mean, suddenly the March 5 ending of the DACA program is not like this hard and fast date anymore. So it gives Congress more time to supposedly fix it. But of course, that hasn't worked out very well either. The actual compromise proposal for doing it went down because it couldn't get over the 60-vote threshold in the Senate because President Trump lobbied strongly against it.
Well, that's enough of that, I think. We'll stay tuned for the rest of this story. Let's turn now to the governor's situation. Rachel, I'll start with you, and I'll ask each of you basically the same question to start with. What is your general take on this whole indictment situation for the governor?
Well, there's, of course, a lot to talk about, but I think on the whole, this is a mess that the state doesn't need right now. You know, there's a lot that we should be working on. There's a lot that the legislature needs to be focused on, and the indictment and now the creation of a committee possibly in the legislature, in the House, to investigate these allegations. These kinds of things will continue to be a distraction from other issues which are important and need to be addressed in the legislature. But I have many thoughts, of course, about the statute itself. I'll defer to some of my colleagues to start.
All right, Bill, what's your general position on this?
Well, I will concede that this indictment that was returned is rather short. It's one little paragraph. There seem to have been 3 witnesses. But on the other hand, that now we've got the Greitens lawyers filing a motion to dismiss, basically saying that the law it can't be applied to a situation a situation where a person takes a photograph of a person who has consensually taken off her clothes and in his house, and not that it would seem like sort of a tacit admission that the governor did that, but they do not explicitly admit it.
This is the expectation of privacy part of this.
This is the whole expectation of privacy part, and what they say is that the statute says that a place where you have a reasonable expectation of privacy is any place, and I'm quoting here, any place where a reasonable person would believe that a person could disrobe in privacy without being concerned that the person's undressing was being viewed, photographed, or filmed by another. So they're saying that if a person takes off their clothes, they shouldn't be surprised if somebody takes the photo of them, even if it's not consensual. I mean, I think where this the sort of fairly stunning places takes the governor's interpretation takes us is that if a person takes off their clothes in the presence of a spouse, a boyfriend, or a person they've just met, and that person then takes, without consent, photographs or videos and puts them on a computer, that they already had surrendered their right of privacy by taking off their clothes. And I think that's a rather extraordinary position. And I think it also, the statute itself says or filmed, so it's like viewed, photographed, or filmed. So they're separate things. It doesn't say and filmed. So filmed is a separate deal from just being viewed.
Mark, why would that be extraordinary?
Well, you just think of some of the fact patterns that it could give rise to. So I tell Bill, come over. I've got a new swimming pool. Let's go swimming. I've got trunks. And we go into, I said, let's just change here in the bedroom. And we both strip down and put on swimming trunks. While Bill may not have a big deal with me seeing him naked, he's not going to want photos taking of him. And think about, and it also goes to this another case that has kind of come out of nowhere, this Paul Henroyd case, which was a former law student. That's exactly what he was doing. He, my understanding.
Background that for us.
Yeah, so he was a law student who what the media said was he invited women to his apartment. He had a camera. It was installed in a clock radio and in his bedroom, and then would record, and then the allegations were shared those videos with other people. So there was no suggestion that these women were there against their will. At least I don't know of that. So it was consensual videos taking. How is that different?
But he was
convicted.
Charged and convicted.
Yeah.
And now he is seeking, through his attorney, to have the Governor Greitens dismiss the case because he feels that the governors did the same thing.
It was interesting, though, because apparently the request was given to Governor Nixon, sat on his desk, and instead of they didn't send it to Greitens, they sent it to Greitens' attorneys. Mm-hmm. I'm not sure about that, yeah.
Yes, I agree. There are real reasons to be very concerned about the implications of the argument in this motion to dismiss. And I just want to add that as of 2017, 38 states and D.C. have laws that specifically outlaw this kind of conduct, right? Taking and distributing private images of intimate partners without their consent. Missouri does not have such an explicit law, and actually just a few days before the governor's indictment, the House had been debating whether to move such a bill forward, the Missouri House of Representatives. So the governor's lawyers are saying right now this sort of behavior is not illegal, is not criminal. And I think it's worth noting that several of the laws in other states specifically talk about the fact that there is an expectation of privacy between intimate partners. So the fact that the lawyers here are saying, look, there's no reasonable expectation of privacy in this situation, that has not been the view of other states.
Let me put something forward that I heard over the weekend that, again, sounds fairly Byzantine to me, but we'll see. The firm that Greitens has hired is Dowd Bennett, which also employs a man by the name of Jay Nixon, who was a former governor. The Circuit Attorney's Office in the city of St. Louis has Nixon's son as part of the staff there. The concern is that a motion could be made to move this ruling on a motion to dismiss to another jurisdiction because of a potential conflict of interest where you have a father and a son on opposite sides of the issue. Move it to Jefferson County or St. Charles County and get a judge that's more favorable, perhaps, to the governor.
Yeah, so I heard that also. It seems like sort of a stretch to me, but that doesn't mean that the governor's lawyers won't try to make the argument. Their interpretation of a place where you have privacy is a stretch to me. Also, this would seem like even more of a stretch. But I mean, think about. Let's imagine you're asking. You hear a public official ask the question: do you think that a boyfriend or a spouse should be able to take pictures of his wife or girlfriend nude and put them on a computer? I mean,
without her consent?
Without her consent. Do you think that any politician would answer, "Oh, that's fine. She doesn't have an expectation of a right to." Of course, they wouldn't say that. Yeah. That no one would ever vote for them. I mean, it just defies common sense.
And I think the most charitable argument right now is for the governor's lawyers to say, of course that would be completely inappropriate and improper, but it's not currently forbidden by Missouri law. Right. I think that's the best case they can make, and they really have only been saying that it's inappropriate, that it's not currently criminalized. They have not been saying, and of course, this would be a terrible thing. And
the statute is the 2015 statute. It was amended in 2000, I think, as of 2017, and a couple of things I think there might be interesting for listeners. One, this is a motion to dismiss, so they're not arguing facts here. They're just arguing law issues, and they've specifically said we're not at all. We're still reserving the issue of consent, whether or not that was. We're not bringing that up now, and we're not going to argue yet whether or not anyone was partially nude or not. We're not arguing. All we're going to say is, like what Bill was saying and Rachel was saying, that this idea that there's no expectation of privacy in a home when you go in and agree to sex. But I just think that's. I agree with what everything was said here. I just think that. Their reading seems it's a very aggressive reading, and I'm just not sure how anyone would go with it.
One other part of their argument, and in this case I think they're accurate, was that the intent of the legislature in passing the law back in 1995 had been to deal with situations like one out of Buffalo, Missouri, where a person running a tanning salon was taking pictures of the women and girls who were tanning there. So that this is, it was like photos in tanning salons or bathrooms that were being taken surreptitiously that they were thinking about. So they weren't really thinking about a situation like the governor's. But the word, you got to look at the words, though, too.
Yeah. They're thinking peeping Toms, basically, is kind of what they're talking about.
But in this case, an element of it is then you have to distribute the image to someone else. So
Or put it on a computer.
Yeah,
I don't know if you have to.
Right.
I don't think they're actually alleging that he distributed
No,
it.
right.
And the indictment is sort of vague on this, right? All it says is the defendant, Governor Greitens, subsequently transmitted the image contained in the photograph in a manner that allowed access to that image via a computer. So I don't think we know right now whether all they're saying is he took a photo on his phone and it automatically backed up to the cloud,
right,
or he emailed it to himself for purposes of using it later, which you could argue is a little bit more purposeful. It's not clear to me exactly what knowledge requirement the statute includes for the transmission aspect.
Whether you had to, like you were saying before, whether you had to have some kind of intent or mens rea to
right.
do
I think there's a good argument that you don't need to know that you're doing it, because the word knowingly appears in the statute in certain places and not there. But it's not. The facts of it have not yet been revealed publicly, so I don't think we know yet what that's going to look like.
Let me interrupt the conversation right here. I have to take a break. We'll do that. Come back and continue the conversation on the Greitens case with our legal roundtable panel. This is St. Louis on the Air on St. Louis Public Radio, 90.7 KWMU. Now back to our conversation with our legal roundtable panel of attorneys, Rachel Sachs, Mark Smith, and Bill Freivogel. Bill, you look like you wanted to add something.
I was just going to add that one other thing that the governor's lawyers and the governor are arguing in this motion to dismiss is that because this law that's being applied against the governor, it was basically for peeping toms, tanning salons, bathroom photography, that and when the legislature passed it, and because there's this doubt that they are raising about what is the reasonable expectation of privacy in a situation like the governor was involved in, that because of those doubts, you can't use it as a criminal statute. You can't convict somebody of a crime on it, because whenever we're talking about a crime and you're going to lose your liberty, it has to be really clear that something applies, a law applies, and makes a particular activity criminal. And that basically it hasn't been applied in this situation before, except for maybe in the case of our Washington U Law School stripper.
We're talking about a Class D felony here. And I've heard some lawyers commenting on this over the weekend, in which they were saying even if you were convicted on a Class D felony, he would probably do no jail time because it's a first-time offense. And Rachel, you're shaking your head. You don't think so?
Oh no, just that I'm not an expert on these particular the sentencing aspect of this, so I wouldn't want to weigh in unduly.
I mean, I think it's pretty likely he would either get if he were convicted, he would get no jail time or very little jail time. The other day I was looking through all the jail times that the Watergate defendants served, and hardly anybody served more than 6 months, for example. So, even big white-collar crimes don't oftentimes end up in really long.
But if he was convicted, I mean, one implication could be if there were impeachment. So I was looking at impeachment in Missouri because I didn't really know what the rules were. And apparently impeachment in Missouri starts in the House of Representatives, kind of like the federal system. But then it doesn't go to the Senate. It typically goes to the Supreme Court unless it's the governor or one of the Supreme Court justices. And then you have a panel. The Supreme Court appoints a panel of, I think the phrasing was something like 7 eminent jurists to hear it. Is that what it is? Yeah. Yeah, 7 justices. Yeah, but there was a Supreme Court case with the Moriarty, isn't that her? Yeah. Who was impeached, where they kind of said you need to have a conviction. Mm-hmm. Now, I've seen some criticisms of that decision, saying you Supreme Court are restricting yourself, but this would fall within that. So you still got to get to the point where the House of Representatives decides to impeach him.
But my question is, forget impeachment, forget resignation for the moment. If he were convicted and even though he did no time, could he still serve as governor as a convicted felon?
I think if he was not impeached, he could.
I don't know the answer to that question. I saw a response. I know you all have on St. Louis Public radio website that he would automatically be removed, and I don't know if that's true or not.
Okay, well,
I'll keep looking.
That a conviction would automatically remove him.
Right. We have a question via Twitter here from Moore writes, is it possible this could be a stretch of the fact that Missouri is a single consent recording state? That is, you can record a phone call without the other person knowing so long as you own the phone.
Well, it is true that Missouri is a single consent audio recording state, but it's really not. It's really not consent that's at issue here. So, maybe the governor wouldn't have been violating the single party consent law, but he is accused of violating the invasion of privacy law. They're two just separate statutes.
Anything else on the Greitens case?
Well, we also potentially had the FBI snooping around, and so I mean, we've got this. This is the part that everyone is paying attention to because they can understand it and because it's so salacious. But I think there's the money stuff that is what my sense is what the FBI is looking at. This dark money for and where it's coming from and whether or not
unrelated to the case at hand.
And who's paying for the lawyers and all that kind of stuff. I don't know. I've not heard anything.
I mean, there are a lot of uncertainty, a lot of questions that are not answered by what we know at this point. Like, for example, the indictment contains the initials that are the same as the victims referred to in the indictment. So does that mean that she testified, or does that mean did she actually say anything? Would she have had to at least verify the recording her husband had taken? Did she testify any further? Does the circuit attorney have the photo? That's not entirely clear to me. Have authorities obtained any kind of surveillance tape inside the governor's house? The motion to dismiss mentions the surveillance tape. Have they obtained any kind of his emails or his computer or cell phone that would have had this on it? I don't think we don't know any of these things.
But Gardner has to have something. Doesn't she?
She's got to have enough to have probable cause.
Exactly.
Right?
Exactly. And she's being charged, of course, of just making this as a political move, if you will. Okay. Well, there's so much we don't know, but we'll be learning a lot more, I'm sure, in the time ahead.
It was interesting that the national GOP governors don't seem to want to spend much time with the governor.
Their executive group.
Right. So they were having a meeting and he excused himself because I don't think they wanted to be seen with him.
Mm-hmm.
Back also on the impeachable offense, do you think it would matter that this occurred before he became governor? I mean, say he was convicted, could you say, well, that happened before I was governor, so it's not an impeachable offense now?
I don't know. I mean, it probably would be a defense that he would try to mount if he were impeached.
And I mean, his lawyers are parsing this stuff. I mean, that motion I thought was really interesting. And this is what lawyers do. They pull apart statutes and look for every little thing. And I thought it was pretty well done. I'm not sure I'm buying it, but I think it was pretty well done.
I think something like just moral turpitude can be enough to impeach. And so an activity like this before you were governor.
Yeah, but the Supreme Court said it had to be a conviction. Although when you look, I think you're right, because when you look at the statute or the Constitution about impeachment, it says habitual drunkenness is one of the, and that's not illegal. It's just moral shortcoming.
Right. Let's move it. Rachel, you look like you're poised.
Sure, and I'll just say that the fact that there's any uncertainty about whether this conduct of taking photos of intimate partners without their consent and threatening to release them publicly, the fact that there's any ambiguity about whether this is illegal, I think is a good sign that Missouri should move forward. The House and Senate should move forward with this legislation, and the governor should sign it.
Is this the revenge porn legislation that we're talking about?
Yes, it is.
And they're right in the middle of that now, as I understand it.
Yes, and I there may be some questions about whether there will be amendments to the legislation in light of the governor's conduct.
Yeah. Okay, let's move on to some other things to discuss. We'll be back to the Greitens case, I'm sure, in the months ahead. A big case today before the Supreme Court is hearing arguments that involves a lot of people in Illinois. It's hearing the case challenging that non-union public employees must pay union dues. It's a precedent involved here set by the Supreme Court 40 years ago. This sounds like right to work.
Yeah, it is right to work in the public context, public union context. And so this is this case, which comes from Illinois, and which has been ginned up and brought with the cooperation of Public Policy Institute over there, Illinois Public Policy Institute, and its affiliate, the Liberty Justice Consortium. It's directly aimed at the power of public employee unions. So what the issue is, even if you're not a member if you're a public employee, and even if you're not a member of the union, you still have a fee taken out of your paycheck. And it's called an agency fee, and it's to compensate the union for bargaining on your behalf. So what Janice, who's a public employee in Illinois, says is that I object to this being taken out of my pay. I also object to I don't want a union trying to get more money for me or my fellow employees from the state, and therefore they are violating my free speech rights. Right. I have a free speech right in connection with any public policy decision, and pay and benefits for public workers is a public policy decision. And we have a Supreme Court that has 4 and probably 5 justices who are very sympathetic to that argument. The guy who's usually in the middle, Justice Kennedy, is not really in the middle on this case. He's a really strong advocate of free speech in this kind of context. So this similar issue was before the Supreme Court a couple of years ago. They ended up divided 4-4 after Justice Scalia died. They would have had 5 votes at that point, almost certainly to come out against, to overturn the 40-year-old precedent, and to really sort of put a dagger in the heart of public employee unions. But he died. Then they split 4-4. He had to have a new case come before him. This is the new case. Apparently, Gorsuch didn't say anything in the oral arguments today, Rachel says. But I think everybody expects Gorsuch to come down with the conservatives and throw out this precedent.
Moving on, Rachel, did you?
Yeah, so I just wanted to give a shout out to a podcast hosted by one of my colleagues at WashU Law, Dan Epps, and his colleague Ian Samuel. And they do a podcast called First Mondays, which is about Supreme Court cases. They profiled this case and had an interesting amicus brief that they talked about, which is filed by 2 law professors who often take positions favored by the conservative wing of the court. These professors, Eugene Volokh and Will Bode, they take the position that there's no First Amendment right to avoid subsidizing speech you disagree with. Compelled subsidies of speech happen on a regular basis, and they're not unconstitutional. So as an example, our tax dollars fund the government, even when it takes positions or does things we disagree with. The government uses tax dollars to fund private organizations who may engage in speech people disagree with, like public defender services or even crisis pregnancy centers. And so Epps and Samuel, they have a hypothetical where they say, look, the state could get around this ruling that the fees themselves are unconstitutional by just taxing public employees and using that to fund the unions to engage in collective bargaining. That wouldn't be unconstitutional. And so the question is whether the ability to do that includes the ability to require union dues in the way that we do now.
Now, one other thing I might add is that if you see this in the larger context, what this really represents is that conservative policy institutes and legal institutes have become enormously powerful in recent years. I remember when I went to Washington in 1980 to cover for the Post-Dispatch. It was just the beginning of the dawning of this growing power of conservative think tanks. And in Illinois, the Illinois Policy Institute and all of its arms has got a tremendous amount of power, even to the extent that they have a set of they're connected with a set of newspapers and the Illinois radio network, and run pro-Governor Rauner propaganda in those newspapers and on that radio network, and pawn it off as actual, unbiased news. Governor Rauner has been a big, proponent of the Illinois Policy Institute, and he was actually involved in the initial attempts to bring this issue to the U.S. Supreme Court.
Okay, you mentioned public defenders, and we've touched upon this many times before, the effort to privatize the public defenders here in the state of Missouri. It's actually going into effect in one county, as I understand it. Texas County this week is going to have to move in this direction, basically because they've got too much work and too little money to do the job properly. As I say, there seems to be a lot of traction building for this. Would we anticipate, do you think, that the legislature might in fact privatize the system?
Well, it looks. It appears as though there are some members of the legislature who think that you could save money by doing this. I'm not exactly sure how they actually save money in the long run. It appears to me as though the public defenders are paid less per case than our private attorneys. But what the state of Missouri should do is they should fund their public defender system, and this has been a bipartisan failure to fund it. It goes to Jay Nixon. It goes. Actually, Greitens has been better than Jay Nixon in funding the public defenders. But still, the funding is way too low to provide the constitutional right of a person to have a lawyer when they might lose their liberty.
There's also a question as to whether there are enough lawyers in rural Missouri to actually get the job done.
So there is a proposed bill that would say the public defenders are only going to handle the Class A and Class B felonies, and all other stuff, which apparently, I didn't know this, it's something like 88% of the workload would go to private attorneys. And as been mentioned, the ACLU is suing, and when you read their brief, it's very interesting. They're not talking about caseload, they're talking about workload. And they're saying you can't just look at the number of cases. You should look at how much time a lawyer should spend with each case, and then let's look at that. And they were saying something like Missouri public defenders have their workload, not their caseload, is something like 250% of what it should be to actually. And as a result, indigent clients cannot see their lawyers, so they stay in jail longer while they're awaiting trial. And it's a lot of this stuff that we've seen in other jurisdictions where poor people are just staying in jail because they're poor.
Got to take another break. We'll do that now. Come back with our legal roundtable panel. Rachel Sachs, Mark Smith, and Bill Freivogel in just a moment. This is St. Louis on the Air on St. Louis Public Radio, 90.7 KWMU. And welcome back once again as we continue the legal roundtable panel discussion with Bill Freivogel, Mark Smith, and Rachel Sachs. I'm wondering if the gerrymandering issue is reaching a point where there might be some sort of national consensus. And I'm basing that on what's happened in Pennsylvania recently, in which the Supreme Court, U.S. Supreme Court, refused to rule 4 Pennsylvania Republicans seeking to overturn the state Supreme Court's redrawing of congressional districts. People seem to think that we might be leaning toward having individual states deal with this as opposed to any kind of a national commission or something.
Well, that might be, but the U.S. Supreme Court taking that action in the Pennsylvania case, I don't think it tells us anything about how will they rule in the 2 federal cases that they have before them, one from Wisconsin and the other from, I think, Maryland. Because the reason that the Supreme Court doesn't want to get involved in the Pennsylvania case is it was decided by the state Supreme Court on state constitutional grounds. And so it would be only in very unusual circumstances that would be too complicated to explain, that the U.S. Supreme Court would find an issue that they really have jurisdiction over. It's a state issue, and they don't want to get involved in it. But it's where the whole redistricting and gerrymandering issue goes will very much depend on what the U.S. Supreme Court says in the Wisconsin case and the other case that they have before them, and we'll have an answer to that later this year.
In that Pennsylvania case, they didn't really issue an opinion. They said the opinion's to come because there's time restrictions. So you may be right. There may be some really interesting reasoning in there that smart lawyers could use in other states but every state constitution is different. I suspect this is going to be very particular to whatever Pennsylvania's constitution says, but it's a different approach. And so maybe people will start looking at their state constitution, see if there's something they can use within that to challenge the redistricting and move it forward. But then you still got to find a state Supreme Court that would be open to that argument.
Another case that a retired Missouri Circuit judge would like the Supreme Court to rule on concerns a sentencing of some years ago in which she sentenced, this is just former Judge Evelyn Baker, sentenced a 16-year-old to 241 years in prison for an armed robbery. That's a pretty excessive sentence, a lot of people might say, but she has regrets over that now, and she would like the Supreme Court to actually make it right. Is this something that the U.S. Supreme Court would likely get involved in a case like this?
Yes. Well, so the background here is that a few years ago, the Supreme Court held that the Constitution prohibits imposing a sentence of life without parole on juvenile offenders who did not commit homicide. That was a case called Graham v. Florida. And in this case, Bostic was sentenced to 241 years in prison for armed robberies he committed at age 16. So he's in this category of juvenile offenders who didn't commit homicides. And the question is whether states can basically circumvent the ruling that life without parole isn't available for them by sentencing minors to hundreds of years in prison. So he's not going to be eligible for parole until he's 112 years old, I read in one of these news articles. And you could very much imagine that the court would want to sort of clean up some of the uncertainty left behind by this ruling.
And I think they have actually indicated some interest in the case because the same week that Evelyn Baker wrote her op-ed in the Washington Post saying that she regretted what she had done, the Supreme Court asked the Missouri Attorney General's office to file a response to the appeal that's before them. When the Supreme Court does that, it shows that they've paid attention to it out of the thousands of other cases that are going in front of the justices all the time. So oftentimes that is a precursor to the Supreme Court possibly hearing the case once they get a response from the state.
But just to make sure people understand, this is only for juveniles, and it's only for the equivalent of a life sentence, something like 120 years or 112, whatever. So it's not – we're still going to have – even if the Supreme Court would take this up, you could still have, I think, long sentences. It just can't be something where there's no chance that this person would ever get out of prison.
She also cites something else that we've been hearing a lot about lately, and that concerns brain development in juveniles. Right. And this is apparently quite a serious issue because the brain is not fully developed, and they're not responsible for a lot of things that they do.
And the Supreme Court takes this seriously.
Yeah.
And that was really the part of the rationale for the Supreme Court decision saying you can't execute juvenile murderers and you can't give life sentences without parole to juveniles.
In Graham, they cited the lack of maturity, the vulnerability to negative influences, and that their character is not well formed. But drawing on some of the science, yeah.
Well, it's getting a lot of attention, needless to say, at this particular time. Bill, I'm going to turn back to you because in your Gateway Journalism Review, you had expressed some concern that Donald Trump appealed for due process in the Rob Porter case. Porter, of course, being his former aide, accused of having physically abused his two wives. You expressed some concern over the use of the term due process by the president. What do you mean?
Well, I mean, he was just the way he uses it is both misleading and hypocritical. So, I mean, in due process, you can't the government owes you due process of the law. They can't take your liberty, your property, or your life away from you without due process of the law. You know, that word due process is like one of the most important phrases in the Constitution. It's the basis for the Bill of Rights applying to the states. It's the basis for individual autonomy of deciding whom to marry, whether to be able to control your body. It's an incredibly powerful word. It basically means like procedural fairness. I mean, Donald Trump was the person who owed Rob Porter procedural fairness. So don't be complaining about procedural fairness. Plus, the president, how much fairness do you owe to a person who's been accused by his previous wives of abusing them? When the person has been given a year of temporary security clearances to view the most important secrets that come before the president. I mean, he's had a lot of due process. The FBI investigated. That's due process. The White House was reviewing the FBI investigation. That was due process. Plus, it's interesting that the president is all for due process, but his lawyers, meanwhile, are in a federal court in New York, saying that one of the persons who accuses him of attacking her sexually, one of the dozen or more people who makes that accusation,
19, I think,
should not have any due process because he's president and he shouldn't have to answer those kinds of claims. Actually, the woman has filed a defamation case against him. He shouldn't have to answer that because he's a president. Well, you know, the Supreme Court made Bill Clinton answer Paula Jones' case. So, you know, due process. Plus, you know, let's take in the broader sort of Me Too movement. I mean, due process is something that the government owes its citizens. It's not something that a civil rights movement owes to the people who have been violating people's rights. The civil rights movement didn't owe George Wallace due process. Mm-hmm. A newspaper, I think, owes a person the kind of, you know, sort of like due process, the fairness of, you know, tell us whether you did this or not. But I just thought he was misusing the word.
Any thoughts on that, Rich?
Yeah, just that, as Bill said, when we use a term like due process, that's a legal term, and those of us who are lawyers know that it has a particular meaning associated with it, and when it's being used more generally, it really is being used to talk about, as Bill was saying, procedural fairness. But Porter had a lot of process. There was an extensive FBI investigation that lasted for months. They interviewed the parties. They gathered evidence. And that seems to be true for a lot of these cases that we're seeing, right? There are internal investigations at a number of these media entities that are leading to the dismissal of these particular perpetrators, or we're seeing extensive media reporting leading to such investigations. And people are being fired, but very few of these people are being criminally investigated and deprived of their liberty. So the amount of process you are due differs depending on the situation, typically. And so here, where we're talking about letting someone go from their job at the White House, where they're privy to state secrets, the level of process you would need may not be, you know, a conviction in a court of law.
Really opened up a can of worms, didn't it, with regard to not only Mr. Porter, but scores of other employees in the White House who don't have those security clearances.
Such as his son-in-law.
Such as his son-in-law, who may be in some difficulty from what you
seems to
read.
Be.
Yeah, okay. Alrighty, I'll turn to my Washington University friends here with regard to a story that just caught my eye, get your reaction to it. A research project being carried out by law students at Washington University, examining U.S. government response to gun violence within the context of international human rights law. Very interesting approach. It'll be interesting to see how that turns out. But what do you make of this process, Mark?
This is not my area of expertise, but I looked at this international inter-American human rights system, and my understanding is that the U.S. government has said we are not bound by their decisions, that we view this organization is setting aspirational standards. I think, having said that, the U.S. government will often respond, but it's not like a court of law where you have a judgment that you can execute. Rachel, you got a different view?
I was just going to give a little bit more background for readers who might not be familiar, for listeners who might not be familiar with what's happening here. Basically, this initiative is being spearheaded by one of my terrific colleagues, Layla Sadat. She's an international law, international human rights expert. And basically the question here is, look, the U.S. has certain obligations under international human rights law, and whether the government's failure to take action to attempt to prevent and reduce gun violence is a violation of our obligations under these international human rights instruments. And many students are working with this initiative in seeking to answer that question. And I think some of them are my own, so that would be lovely.
Well, two areas that are cited specifically, which are interesting. They look at the fact that the Congress allowed the assault weapons ban to expire, and they're also looking at allowing concealed carry permits valid in one state to be valid in all states at that point. And they think that this may lead to a violation of those international rights.
Yeah, that latter law, the Concealed Carry Reciprocity Act of 2017, which has passed the House, I think is something people should really pay attention to because, it basically is saying that a state like New York or California or our neighbor Illinois that has pretty tougher gun laws will have to basically follow the laws of the more lax states and let people who have concealed carry in other states conceal and carry in their states. So, for example, New York City could not ban people from other states carrying guns at the New Year's Eve celebration. The one thing about this about the whole gun control argument that really drives me crazy is, we've talked a lot of times about the Heller decision where the Supreme Court said there's a constitutional Second Amendment individual right to have a gun in your house to protect yourself. But the NRA has taken that to say any kind of gun law is going to violate my Second Amendment rights. It's not true. It very specifically said in the decision by Justice Scalia,
right,
you still can have concealed carry laws. You still can outlaw machine guns. You still can outlaw sawed-off shotguns. You still can outlaw
still ban your
assault
schools.
Rifles.
Yeah.
Do you see anything developing in the wake of that horrific shooting in Florida, likely to change national thinking on gun control?
That's a political question. I mean, and it's going to be up to state.
Well, you were in for office once.
We just know how that came out.
I think these students are a thing that's different. And if these amazingly well-spoken students can really have their movement, Never Again movement, spread and become almost like if some of these March and April days that they have set aside become almost like a national student strike, I think it could have an effect. I mean, the first graders in Connecticut, they couldn't go make an argument.
That's true.
But these are very well-spoken high school students, and people are listening to them.
And they've already had quite an impact on corporate partners of the NRA who have disassociated themselves or dropped their affiliations with the group. So, and we've seen Governor Scott in Florida come out and take certain positions that are more favorable to what they've been asking for. It remains to be seen, obviously, whether those will go forward and whether anything will happen at the federal level. But I wouldn't count them out.
Well, some people are taking them seriously when the immediate reaction was to charge some of these kids with being actors who are, not really involved in the incident, but were just brought in there to be emotional and to try to change public opinion. I mean,
Dana Lesh is a spokesman for the NRA and nationally spoke to the CPAC group, was on the ABC News program over the weekend, and the way in which she misleads about what the NRA's position is really sort of disgusting. She's a former Missourian, by the way.
Yes. Okay, that's just about wraps up all that we have. Any final thought in 10 seconds that anyone feels we should have said and didn't?
I think we got to everything.
Okay, well, let's end it right there. My thanks to you, Mark Smith, for being with us once again. And Rachel Sachs, great to see you. Thank you for being with us.
Thank you.
Freivogel, same to you. Good to have you with us, and we'll get together again in about a month. Archive versions of past St. Louis On the Air programs available for download or podcast at stlpublicradio.org/STLonair. St. Louis On the Air is a production of St. Louis Public Radio, 90.7 KWMU. Thank you for listening. I'm Don Marsh.
Support comes from the Missouri Forest Products Association, providing more than 41,000 jobs in the production of wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details at choosewood.com.